Hello and welcome to Daily News Simplified, the what, why and how of newspaper analysis. Today we are going to cover Delhi edition of Hindu newspaper dated 7th of December 2019. The articles which we are going to cover are displayed on the screen. Let's now begin with the discussion. This article has been taken from page number 10 and it has been published in the editorial. This article deals with the two recent reports published by Intergovernmental Panel on Climate Change IPCC. One of the reports deals with impact of higher global temperatures on land and another one deals with the impact of higher global temperatures on oceans and cryosphere. Now, special report on climate change and land and special report on ocean and cryosphere in a changing climate. Reports given by IPCC becomes extremely important because they are the most authentic source of literature as far as the direction of climate change as well as its impact on various aspects are concerned. From the perspective of prelims examination, it becomes important under general issues on environmental ecology, biodiversity and climate change. From the perspective of GS1, it becomes important from the perspective of geographical features and their location changes in critical geographical features including water bodies and ice caps. As the second report deals solely with ocean and cryosphere. And also there is a line in GS3 syllabus conservation, environmental pollution and degradation, environmental impact assessment. So what we will do is that we will analyze the important aspects of both these reports and we will see that what IPCC has tried to highlight in these two reports and then we will discuss the key points raised in the editorial today. Now this report released by IPCC in 2019 addresses greenhouse gas fluxes in land-based ecosystems, land use and sustainable management in relation to climate change adaptation, mitigation, desertification, land degradation and food security. This report follows the publication of other recent reports including the IPCC Special Report on Global Warming of 1.5 degrees C and the assessment by Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services IPBES on land degradation and restoration as well as Global Land Outlook of UNCCD, which is United Nations Convention to Combat Desertification. Now these three particular reports point towards the contribution of land in global warming as well as how land can be utilized in mitigating the climate change. It is important to remember these three reports as far as prelims examination is concerned because at various instances UPSC has directly asked mentioned report is released by which of the following organization. From the perspective of environment, climate change and global warming, IPCC, IPBES and UNCCD become important. Now there are four key aspects to the report. First part deals with people, land and climate in warming world. The second part deals with adaptation and mitigation response options. Now the first part talks about the importance of land, which provides the principal basis for human livelihoods and well-being, including the supply of food, fresh water, and multiple other ecosystem services, as well as biodiversity. Human use directly affects more than 70% of the global ice-free surface. Land also plays an important role in the climate system. Now, the same part states that the effects of global warming and climate change are more visible over land as compared to that overall Earth. This is proven in the report with the help of a graph which plots two different temperatures in successive years. Now the first is change in surface air temperature over land and the plot with the darker shade of black shows change in global mean surface temperatures. And as you can see that the line plotted with the grey color is significantly higher for each year as compared to the line plotted with the darker shade of black, which shows that the impact of climate change has been much more on temperatures over land and hence the impact of climate change is being observed more on land if we compare it to overall Earth. According to the calculation by IPCC, since the pre-industrial period, the land surface air temperature has risen nearly twice as much as the global average temperature. Climate change, including increase in frequency and intensity of extremes, has adversely impacted food security and terrestrial ecosystems as well as contributed to desertification and land degradation in many regions across the world. Then in part 2, 3 and 4, the report talks about the mitigation and adaptation options or the responses to these climate change impacts that global society can adopt. We will discuss them in very short. So first, the report talks about land-based options that deliver carbon sequestration in soil or vegetation such as afforestation, reforestation, agroforestry, soil carbon management on mineral soils or carbon storage in harvested wood products. Then it also talks about the significance of wetlands and peatlands that can continue to sequester carbon for centuries. Then report talks about a number of other options such as land management, which includes improved management of cropland and grazing lands, improved and sustainable forest management. It also talks about controlling land degradation and combating desertification. From the perspective of UPSC examination, we should keep in mind that there is a report which is Special Report on Climate Change and Land released by IPCC. Based on these three following reports, it talks about people, land and climate in a warming world, and then it talks about the response mechanisms which will be based mainly on land to deal with the climate change. Let's now move on to the second report which deals with the cryosphere and oceans. The ocean and the cryosphere, that is the frozen part of the planet, play a critical role for life on Earth. A total of 670 million people in high mountain regions and 680 million people in low-lying coastal zones depend directly on these systems. Now, this report provides new evidence for the benefits of limiting global warming to the lowest possible level in line with goal that governments set themselves in 2015 Paris Agreement. Urgently reducing greenhouse gas emission limits the scale of oceanic and cryospheric changes. So the report starts with the discussion on major changes in high mountains which will affect downstream communities. Now, one of the important observation of the report is that the smaller glaciers found in Europe, Eastern Africa and tropical Andes are projected to lose more than 80% of their current ice mass by 2100 under high emission scenarios. The report also talks about how this melting of glaciers will lead to people in mountain regions being exposed to increasing intensity of hazards as well as reduction in water availability. Then report talks about the impact of melting cryosphere on rising sea levels. The report states that while sea level has risen globally by around 15 centimeter during 20th century, the rate of this rise has increased by more than twice in the last decade. The report also states that the sea level will continue to rise for centuries. It could reach around 30 to 60 centimeter by 2100 even if the greenhouse gas emissions are sharply reduced and global warming is limited to well below 2 degrees Celsius. That means that even if we are able to achieve the target set under Paris climate deal, then also the rise in sea level is inevitable. Then in the same chapter, the report talks about declining Arctic sea ice as well as thawing permafrost. Permafrost ground, which basically means the ground which is freeze throughout the year, has been frozen for many years. Now, due to the impact of climate change, this permafrost ground that has been frozen for many years is warming and thawing, and widespread permafrost thaw is projected to occur in the 21st century. And if greenhouse gas emissions continue to increase strongly, there is a potential that around 70% near surface permafrost could be lost. The report also talks about the rapid rate of decline in Arctic sea ice. Now, as far as the impact of global warming on ocean ecosystem is concerned, the report highlights the following points. The first most important impact of global warming is the changing ocean chemistry which is being observed throughout the world and which is leading to changes in food web, with impacts on marine ecosystem and also on the people that depend on them. Now, as far as the ocean chemistry is concerned, ocean warming reduces mixing between the water layers, and as a consequence, the supply of oxygen and nutrients for marine life is hindered. Now, increasing greenhouse gas emission, led mainly by carbon dioxide, has led to ocean acidification. It is estimated that around 20 to 30% of human induced carbon dioxide emissions since 1980s have been taken up by the oceans. Now, the further increase in carbon dioxide emission will lead to further ocean acidification. Now, this overall combined together leads to changes in distribution and abundance of marine life in coastal areas, in the open ocean and at seafloor. Shifts in distribution of fish populations have reduced the global catch potential. In the future, some regions, notably tropical oceans, will see further decreases, but there will be increases in others such as Arctic oceans. Communities that depend highly on seafood may face risks to nutritional health and food security. Now, the editorial which has been published today, on the backdrop of these two particular reports, it is important for us to show extreme seriousness towards the implementation of Paris Agreement. Otherwise, the impacts of climate change will reach beyond our capacity to manage their impacts. Now, a particular term, Article 6 of the Paris Agreement, has been used in the editorial. Let's now understand this term. Let's now rewind a little bit to understand the targets of Paris Agreement. Now, the 194 parties to UNFCCC committed to shifting the world's course towards sustainable development and holding the increase in global average temperature to well below 2 degrees Celsius above pre-industrial levels and pursuing efforts to limit temperature increase to 1.5 degrees Celsius above pre-industrial levels, which means that the global community has committed to contain the increase in global temperature by 1.5 degrees Celsius under Paris climate deals. Now, as you already know, in order to achieve this goal, all participating countries are required to set national GHG emission reduction targets, which are commonly known as nationally determined contributions, under which each country will come up with their own targets, keeping in account their level of development and their capacity to reduce those emissions. Now, the next review of these NDCs will take place in 2020, and it will be necessary for countries to increase ambitions in order to meet the goals of Paris Agreement. NDCs need to be progressive during each successive review, which means that countries have to come up with more and more reduction targets, and UNFCCC understands this would significantly reduce the risks and impacts of climate change. Now, one of the keys to this increased ambition lies in the implementation of Article 6 of Paris Agreement. Now, this Article 6 has been in news because Conference of Parties 24, which was held in Katowice, which is Poland, in last December, participating countries reached an agreement on the implementation of the Paris Agreement, the so-called Paris Rulebook, but could not reach an agreement on the implementation of Article 6. This is why Article 6 of the Paris Agreement was the focus of much attention at United Nations Climate Change Conference in Bonn. Let's now understand Article 6. Article 6 of Paris Agreement deals with commodifying the carbon reductions, which aims at promoting integrated, holistic and balanced approaches that will assist governments in implementing their NDCs through voluntary international cooperation. Under this mechanism, countries with low emissions would be allowed to sell their exceeding allowance to larger emitters, with an overall cap of greenhouse gas emissions ensuring their net reduction. Let's understand this by an example. So let's say the targets were set for around reduction of 100 tons, but in the same time frame, the country achieved increased reduction by more than 20 tons. Now this country shall become eligible for selling this extra reduction of 20 tons to a country which has not been able to meet its target, and hence the supply and demand mechanism supply and demand for emission allowances would lead to the establishment of global carbon price that would tie the negative externalities of GHG emissions to the polluters, which means that the countries which are emitting more than their nationally determined contributions will have to purchase or buy emission certificates from the countries which have been able to save or reduce on their carbon dioxide emissions. By paying a price on carbon, states exceeding their NDC would bear the cost of global warming. Through this flexible approach, GHG emissions would undergo a strong decline, coupled with stimulation for innovative and cleaner technologies and an overall transition towards a low carbon economy. In addition to being a driver for carbon pricing, the successful implementation of Article 6 would create a new channel for climate finance and lead to technology transfer and capacity building. Now, in totality, the new IPCC assessment underscores the need for unprecedented and urgent action in all the countries that have significant greenhouse gas emissions. These reports strengthen the case for industrialized nations to provide liberal, transparent funding to developing countries under Paris Agreement, reinforcing the principle of common but differentiated responsibilities and respective capabilities, and recognizing that rich countries reduce the carbon space available to the poor. Now, this reduction of carbon space, which will be made available to the poor countries, will be made through a mechanism of Article 6, which will be of carbon pricing. As there is a large gap between the planned emission cuts and what needs to be done by 2030 to contain global temperature rise at 1.5 degrees Celsius, it is extremely important that countries arrive at a consensus as far as the implementation of Article 6 is concerned, as it is extremely crucial for global climate change mitigation. With this, we will move on to the next news. Now, this news has been taken from page number 12. Rajya Sabha discusses bill to scrap poll spend limit. Now, the Rajya Sabha on Friday discussed two private members' bill to do away with the cap on election spending by candidates and to establish a committee on foreign investment to prevent threats to national security. From this point of view, it is important to understand that there is a provision through which members of the parliament who are not the minister can also introduce a bill and get it passed through both the houses of parliament. Now, it gets covered under prelims syllabus Indian Polity and Governance, Constitution, Political System. It is important to analyze this prelims question asked in prelims 2017, under which UPSC asked, with reference to the Parliament of India, consider the following statements. First option, a private member's bill is a bill presented by member of parliament who is not elected but only nominated by the President of India. And the second option read, recently a private member's bill has been passed in the Parliament of India for the first time in its history. It is important to understand the provisions related to private member's bill. But we will start by first understanding what a private member bill is. Now, a private member bill is a bill which has been introduced into the House of Parliament by a person who is not a minister, which means all those members who are not the part of the government, and if they introduce a bill, that shall be categorized as private member bill. It doesn't matter whether they belong to the ruling party or the opposition parties, but they should not be the part of Council of Ministers. Now, one of the tasks of the member of parliament are to raise various issues which are relevant for the society as well as for the country. Now, due to the limited capacity of the government to focus on all issues, it becomes important for individual MPs to bring the attention of the government on various issues and gaps in existing legal framework which are not being focused by the government and which also require legislative intervention, and hence this provision for introduction of private member bill has been provided for. Now, at the same time, it is important to understand that what are government bills or also known as public bills. Now, on the contrary to private member bills, bills introduced by ministers are referred to as public bills. They are backed by the government and reflect the legislative agenda of the government. Now we shall see that what are basic differences between public and private bills. Public bill is introduced in the parliament by a minister. Now, since public bills are introduced and backed by the government, they have higher chance of being passed in the parliament. Now, if a private bill is not passed by the parliament, it shall have no impact on the stability of the government. Now, on the other hand, rejection of public bill by Lok Sabha amounts to the expression of want of parliamentary confidence in the government. Now, as far as the drafting procedure of bills are concerned, The drafting of public bills is done with the process involving concerned departments in consultation with the law department. On the other hand, the drafting procedure of private member bill is very different and it is up to individual member of parliament to draft the bill. After understanding the basic differences between public and private bills, let's now look at few other aspects of private member bill. Now, as far as the introduction of private member bills in the Houses of Parliament is concerned, the admissibility of the bills, whether the bill need to be admitted on the floor of the House for discussion or not, is decided in case of Rajya Sabha by the Rajya Sabha chairman, while in case of Lok Sabha it is decided by the Speaker of the Lok Sabha. Now, it is important to know that notice period of at least 1 month needs to be given by the member of parliament who is tabling the bill before the actual tabling of the bill can take place. So, for example, if the member of parliament is thinking of tabling the bill on 1st of December, he or she needs to give notice to the respective chairman and speaker of the houses before 1 November. After the admission of the bill, the House Secretariat, which is the staff of both the houses, examine it for the compliance with constitutional provisions and rules on legislation before listing it for the debate. As we know that there is no involvement of law ministry in the formulation of the bill, therefore this mechanism has been developed to ensure that the bill is in compliance with various other legislations as well as the constitutional provisions. One important piece of information from the point of view of prelims examination is that while government bills can be introduced and discussed on any day, private member bills can be introduced and discussed only on Fridays. And since yesterday was also a Friday, and hence you can see that the two separate private member bills were tabled on the House of Rajya Sabha. Now, as far as the history of private member bills are concerned, 14 private member bills have been passed so far. So moving on to the prelims question we just saw on the first slide, with reference to Parliament of India, consider the following statements. A private member's bill is a bill presented by a member of Parliament who is not elected but only nominated by President of India. This is wrong, as private member bill can be presented by any member of Parliament whether nominated or elected. And second option is, recently a private member bill has been passed in the Parliament of India for the first time in its history. And we know that 14 private members bill have been passed so far from both the houses of parliament, and hence option 2 is also incorrect, which leads us to the right answer, which is D, neither 1 nor 2. We shall now move on to the next news. Now the next article for consideration is that of NHRC. Now page number 1 and page number 10 contain two news which throw a limelight on the functioning and the effectivity of National Human Rights Commission. The state apparatus has resorted to tools to tackle crime and law and order situations in the country via extrajudicial means, and there have been a lot of extrajudicial killings, proven or unproven, in the country in the recent past. Clearly, extrajudicial killings are violation of human rights. The existence of National Human Rights Commission in the country since 1993 raises the question on the effectivity of this institution. So NHRC becomes important from the point of view of GS2 syllabus, statutory, regulatory and various quasi-judicial bodies, as we know that it has been constituted through an act of parliament and hence it becomes a statutory body. So first we will understand the NHRC and its composition. Then we will look into the functions which have been envisioned for NHRC. Then we will look into the various aspects which have stopped NHRC from functioning like a proper human rights commission. This becomes important from the perspective of mains examination to know that what are the reasons which have stopped NHRC from functioning in its full capacity. Let's now start the discussion. National Human Rights Commission, or NHRC, was established through Protection of Human Rights Act 1993, which has been amended by Protection of Human Rights Act 2006, and hence it becomes a statutory body. Now, as far as the International Convention is concerned, it is in conformity with the Paris Principles, adopted at the first International Workshop on National Institutions for the Promotion and Protection of Human Rights held in Paris in October 1991 and which has been subsequently endorsed by General Assembly of the United Nations. On the dawn of last decade of 20th century, it was felt that there is a need for each country to create its own institution for protection of human rights, and for that Paris principles were created, and it became mandatory for all the parties to constitute a national level commission in their respective countries, and National Human Rights Commission is the result of the same principle. Now, coming on to the human rights, under the Act, Section 21D defines human rights. Now, under the section, human right has been defined to mean rights related to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. So, all those rights which have been given by the Constitution or various laws in India shall be constituted as human rights. Now, for the protection of fundamental rights, we have Supreme Court, and for protection of all other rights, including fundamental rights, we have National Human Rights Commission. Now, moving on to the composition of the commission. Now, the composition of the commission has been written in points. It shall be headed by a chairperson. Now, there is a condition that only a retired Chief Justice or a judge of Supreme Court is eligible to become a chairperson. Apart from that, there will be two other judicial members, one of whom shall be a judge of Supreme Court of India and another one shall be a Chief Justice of High Court of India. Shall be a Chief Justice of a High Court of a state in India. Now, three other members are needed as a member, out of which at least one shall be a woman to be appointed from amongst persons having knowledge of or practical experience in matters relating to human rights. In addition, the chairpersons of National Commission on Scheduled Castes, Scheduled Tribes, National Commission on Women, National Commission on Minorities, and National Commission on Backward Classes, as well as National Commission on Protection of Child Rights and Chief Commissioner for Persons with Disability shall serve as ex officio members. Now, this term ex officio means that by virtue of them being holding the position of chairpersons of these commissions, they shall automatically become the member of NHRC. So, for example, if a person is appointed as a chairperson of National Commission on Scheduled Castes, that person will automatically become a member of National Human Rights Commission. Moving on to the functions of NHRC. Now, the functions of the commission have been envisioned under Section 12 of the Act. Now, the first and the foremost function of NHRC is to conduct inquiry into complaints of violation of human rights or negligence in prevention of such violation by public servants. Now, people in India can complain to NHRC about what they see as a violation of their human rights by some public agency or a government agency or the state of India. As far as the negligence in prevention of such violation by a public servant is concerned, it means that there are certain events where the government or the police or other functionaries of the state have not been able to prevent a violation of a private person in India, and hence NHRC has the power to conduct inquiry into such complaints. Now, it also studies treaties and international instruments on human rights and makes recommendation for their effective implementation to the Government of India. It is also responsible for spreading of human right awareness amongst the masses. The existence of such a national level commission will have no benefit for the society if the people are not aware about it, and hence this is one of the very important responsibilities given to NHRC to carry out information and awareness campaigns regarding not only the human rights available to the citizens and people residing in India, but also the remedies available to them. It also encourages the efforts of all stakeholders in the field of human right literacy, not only at the national level, but at international level too. So the functions of NHRC are not only confined to the people in India, but it also participates in debates and discussions across global platforms to increase human rights literacy throughout the world. Now, moving on to the most important aspect of NHRC, which shall be extremely relevant from mains perspective, is that why NHRC has not been able to play the role for which it was created. So there must be certain issues which are creating hurdles in the actual implementation and functioning of NHRC mechanisms. Now, first we will discuss the larger aspects and then we will discuss the practical limitations. Now, NHRC's recommendations do not reach to the ground level as the NHRC does not have the backing of Protection of Human Rights Act to penalize authorities which do not implement its orders. Which means that upon conducting inquiry, if NHRC finds that there was a flaw in which the police or any other state institution operated, they cannot penalize the authorities. That is why NHRC has been called as toothless tiger. Also, there are various human rights violations which take place through the hands of private parties, and Act does not categorically empower NHRC to act when such a violation takes place. The Act requires that 3 of the 5 members of NHRC must be former judges, but does not specify whether these judges should have proven record of human rights activism or expertise or qualifications in the area. Which means that the people appointed as a members of Human Rights Commission might or might not have expertise in dealing with human rights issues, which becomes extremely important when matters are brought to their attention, and lack of such expertise becomes a big roadblock. Regarding the other 2 members, the act is vague. As we just saw, it just says that persons having knowledge and experience of human rights, which is not sufficient enough or narrowed down criteria. Under the Act, Human Rights Commission cannot investigate an event if the complaint was made more than 1 year after the incident, which is one of the biggest flaws of the Act. A lot of human rights violation brushed under the carpet and come to limelight many years after they were committed. And under the provisions of the Act, National Human Rights Commission is not empowered to deal with such acts if they were committed more than 1 year before. Now, last and one of the most important issue with NHRC is the limitation it faces while dealing with the security forces in the country. The powers of the NHRC relating to violations of human rights by armed forces have been restricted to simply seeking a report from the government and then issuing recommendations. So it has been specifically stated if the incidents of human rights violations by the security forces come in the limelight, then NHRC can only seek a report from the government and not do anything else. Then there are certain other practical or logistical issues relating to functioning of NHRC. Now the first issue is non-filing of vacancies. Most human rights commissions, for example, State Human Rights Commission and National Level Human Rights Commission, are functioning with less than prescribed members. This limits the capacity of commission to deal promptly with complaints, especially as all are facing successive increases in the number of complaints each day. Then second issue is non-availability of funds. Now, scarcity of resources, or rather resources not being used for human rights related functions, is another big problem. Large chunk of the budget of commissions go in office expenses, leaving disproportionately small amount for other crucial areas such as research and rights awareness programs. Then the issue of too many complaints. The flooding of NHRC with too many complaints. NHRC is deluged with too many complaints. Hence, in recent days, NHRC is finding it difficult to address the increasing number of complaints. This can also be taken as a success of NHRC, as making people aware of their human rights was one of the functions envisioned in the Act, and hence filing of too many complaints somewhere shows the success of NHRC in making people aware of their rights. Then the last issue related to functioning of NHRC is the bureaucratic style of functioning. As Human Rights Commission primarily draw their staff from government departments, either on deputation or re-employment after retirement, the internal atmosphere is usually just like any other government office. Strict hierarchies are maintained, which often make it difficult for complainants to obtain documents or information about the status of their case. So all these issues combined together make the functioning of NHRC extremely ineffective, and hence the enforcement of human rights becomes difficult. It is important for the government of India to take proper measures to rectify these issues in the Act as well as related to the practical functioning of the NHRC. Let's now move on to the next news. Now, this article has been taken from page number 1 and it has been the most talked about news in the past week. Now, four accused in Disha's murder killed near Hyderabad. The four accused in the gang rape and murder of 27-year-old Disha were shot dead by police near Hyderabad in the early hours of Friday. The incident comes exactly a week after they were arrested. Now, according to the police, the shootout took place between quarter to 6 a.m. and 6:15 a.m. near Chattanapalli underpass in Rangareddy district, where the charred body of the girl was found. The accused tried to flee when they were taken for reconstruction of the crime scene. Now, this particular news becomes extremely important from the perspective of GS4 as well as interview point of view. As we know that the results of main examination 2019 are around the corner and interviews shall start very soon, and hence the board might ask you to express your views regarding such a killing. Now, obviously, we don't know what actually happened at the crime scene, but the incidents like this have also happened in the past where police tried to encounter or actually killed the accused persons and took their lives to administer justice and then created a crime scene in which the action of the police was held to be legal. Now, as far as the GS4 and interview is concerned, it is important for us to analyze few issues arising out of this incident. As we know that under Article 21, given in Part 3 of the Constitution of India, which deals with the fundamental rights, it states that no person shall be deprived of his life or personal liberty except according to the procedures established by law. That means, although it is allowed for the state of India to take life of people, but it shall be only done after such a law has been enacted. And we know that there are various laws under which capital punishment or death sentence is given. But case of extrajudicial killing, which means that killing of person by governmental authorities or individuals without the sanction of any judicial proceeding or legal process. Although right now we do not have all the data or the facts of the incident to state that police deliberately took the lives of these accused, but there are other instances as well in which it was proven that the action of police was totally illegal and hence they can be categorized into extrajudicial killings or fake encounters. Now, in the recent case, there are four main points which need deliberation. First is the statements given by our MPs to publicly take away the lives of the accused in the past week. Now, this is extremely important because these MPs enact laws, and when inside the parliament they talk about not following the process created by laws which they themselves create, which shows that they themselves lack trust in the laws created by the institutions in which they are members. This communicates a wrong signal to the society as a whole, as they are themselves people's representative. The second is that we need to restate the importance of due process. So, for example, if police start using these measures very regularly and if it becomes a norm, then it is clearly a violation of due process established by law, which is emphasized by Article 21. And violation of due process by one of the institution will encourage other institutions as well as the society to not follow the due process, and hence it may lead the society into chaos. Now, the third most important aspect which has arisen from this incident is the issues with the police. As we know that maintaining law and order is the prime responsibility of the police, sometimes the impression is created that police is not functioning the best way, and hence exercises like extrajudicial killings or fake encounters look more like an image makeover exercise by the police. Rather than taking the preventive or precautionary measures to make sure that the society is safer for women, the police resort to post facto steps like fake encounter of the accused. Then fake encounter on behalf of police also shows the lack of faith in judicial process, as we know that judicial process in India is extremely time taking, and hence to calm down the public perception, police resort to fake encounters. Also, one of the very practical questions being asked right now is that so far the people who have been killed in the encounter were accused and not the convicted criminals. And also, how do we know that if there were more accused or not? There could have been 8 people involved in the gruesome act of rape, but just by encountering 4 people, we think that the justice has been done. But there could be more people involved in the incident, but since the case will now be closed down, those person could flee justice. Also, the celebration which this incident has invited in the overall society compels us to ponder upon the state in which the Indian society is right now. The incidents of mob lynching, along with extrajudicial killings being celebrated, shows that people more or less have lost faith in the due process established by law, and they are more inclined towards immediate remedy or immediate justice being served. It is important in this respect to know that Supreme Court in 2014 judgment has given elaborate guidelines to investigate all such matters of fake encounter or extrajudicial killings, the details of which can be found in PDF. Now the next article has been published on page number 5. Supreme Court judge calls for early legal aid to poor. Now, it becomes important in this context to have the basic information about NALSA. Now, Article 39A states that the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizens by reasons of economic or other disabilities. As we know that Article 39A has been included in Part 4 of Constitution of India under directive principles of state policy because of reasons of economic or other disabilities, which means that if citizens are not able to afford access to justice, then it shall be the duty of the state and the government of India to enable those people to access justice in an effective manner. Now, in pursuance of this objective, the National Legal Services Authority NALSA was constituted under Legal Services Authority Act 1987. It provides free legal services to the weaker sections of the society and organizes lok adalats for amicable settlement of disputes. So, if the question is asked, who is the agency responsible for organizing lok adalats, then it shall be NALSA. Now, in every state, State Legal Services Authority has been constituted to give effect to the policies and directions of the NALSA and to give free legal services to the people and conduct lok adalats in the state. The Chief Justice of India is the patron in chief, and the senior most judge of the Supreme Court of India is the executive chairman of the authority. Let's now take up questions for prelims examination. Consider the following statements. Part 3 of the Constitution deals with right to life and personal liberty, which is correct. A person cannot be deprived of right to life in India, which is incorrect, as we know that under Article 21, a person can be deprived to right of life in India if that procedure has been established by law. Hence, option 1 is correct, while option 2 is incorrect, and hence the right answer is A. Moving on to the next question. IPCC is an intergovernmental body of United Nations, which is correct. And the second option is the IPCC produces reports that contribute to the work of UNFCCC, which is also correct. And hence the right option is C, both 1 and 2. Moving on to the next question, the first option is all members of NHRC should be judges, which is incorrect. And the second option is Protection of Human Rights Act 1993 does not define human rights, which is also incorrect, as we just saw the section 21D of the act defines what will be the human right in India. And hence the correct answer is D, neither 1 nor 2. With this, we come to the end of today's discussion. Let's have a look at the question of the day.